She is the woman who charged a lieutenant general. Today, Advocate Andrea Johnson, head of South Africa's top anti-corruption unit, IDAC, sits before the Madlanga Commission with a criminal docket hanging over her own name. 30 years a prosecutor, and she tells the commission that what came next was a first. Mrs. IDAC, you and your guys have gone too far. Get body bags ready. A death threat straight to her phone days after a stranger cornered her and her daughter at their own gate. The unit she leads arrested General Kumalo for alleged state capture inside crime intelligence, looted funds, bypassed vetting, properties. But now Johnson faces allegations of a so-called Khan-IDAC cabal and a claim that she disclosed a police docket to a general under investigation. Her response? She invokes her right to silence, the corruption buster, refusing to incriminate herself. Caught contradicting her own affidavit, conceding powers she just denied, a prosecutor now in the dock. If you want the story South Africa's headlines won't slow down for, like, subscribe, hit the bell. Let's go inside.
Paragraph C. The arrest of Lt-Gen Kumalo. The evidence before this commission is that Lt-Gen Kumalo was arrested in a dramatic fashion. Nothing can be further from the truth. It is important that I address this aspect as well. Paragraph 13. Lt-Gen Kumalo was arrested on 26 June 2025 at Oliver Reginald Tambo International Airport, Otia. Only 2 senior criminal investigators in IDAC, senior criminal investigators within IDAC, were tasked with the exercise and effected his arrest. It was Mr. Sunil Belochan and Ayandambalo, in brackets, the investigators. If I may then pause here, yes. Commissioners, and Advocate Selo, to go to the last statement, statement number 3.
You deal with that correction at your paragraph 10.1?
That is correct. So paragraph 14, as it reads in the original...
Before we do so, what do you suggest? Are you going to amend some parts of that paragraph, of the current paragraph 14 of the main statement, or are you proposing an entire deletion of that paragraph and substitution?
An entire deletion of that paragraph, as well as paragraph 15.
Thank you.
Because they should read correctly, and as they currently stand in the original affidavit, they do not read correctly.
Okay. Then let's deal with the first.
Paragraph 14 of the original affidavit to be deleted and to read as it does in paragraph 10.1 of the third statement. I say in 10.1, paragraph 14 must be replaced and should read as follows. Lt-Gen Kumalo was arrested after he had landed at the Oliver Reginald Tambo International Airport, Otia. I do not recall where he was traveling from. I was informed that, at the time, his co-accused had already been invited to report to the Brooklyn police station. That is the correction.
No.
25.1. The manipulation of recruitment processes and appointment of persons without suitable qualifications into senior strategic posts in the criminal intelligence unit. 25.2. The bypassing of vetting processes, which, among others, manifested itself in the failure to apply for and get top secret clearances where required. A standard requirement for crime intelligence unit personnel, especially senior appointments. And at 25.3, the appointments of persons not suitably qualified and or experienced as a form of gratification for their collusion later in the looting of state funds, for example, the purchase of properties. 26. As I indicate somewhere towards the end of this affidavit, I intend to apply for leave to testify before this commission. If leave to do so is granted, I will get an opportunity to expand on the issues to which reference is made above. State capture is a type of systemic political corruption in which private interests significantly influence a state's decision-making processes to advantage and or benefit of certain individuals. 27. When one looks at all the cases referred to IDAC by Mr. Adams, they depict the capture of systems and processes for private interests by the head of CI and other senior managers. This too is an issue I intend to testify about should I be granted leave to. 28. The picture that has emerged is that the appointment and installation of certain persons in certain positions within the Crime Intelligence Unit, CIU, by Lt-Gen Kumalo and his co-accused persons helped them strategically to access funding without following proper processes. This is because their token appointments would not stop them from their unlawful acts. Was affected before 26 June. I received a death threat directly on my cell phone. It read, Mrs. IDAC, you and your guy Shabalala, Perumal, Padiachi, and Belochan have went too far. You're going to wish you did not. I think everyone that has the document can read that word.
Yes.
With us, get body bags ready, close quote. 38. In my long career as a prosecutor, this is the first time that I received a death threat. The NPA has put several measures in place to secure myself and other colleagues.
Before you move from that topic, this sounds like a serious threat. Did you, or by you I mean IDAC, did you cause for the matter to be investigated to get to the bottom of this threat? I do appreciate that measures have been put in place to secure your safety and the safety of your colleagues. But I'm more interested in investigating the matter and finding the source of the threat. Were such steps taken? Are you aware?
The matter was escalated to the Risk and Security Division of the NPA. They did follow up on that message. It was one of those phones that didn't have a registered SIM card, so it sent a message and you couldn't then go ahead and trace the user of the telephone.
The so-called burner phones.
That is correct, Commissioner. I am aware, however, Commissioners, that later on, they were able to determine where a group from whom it might have come. And I'm prepared to rather write that down because it might be a person who's also a subject at the Commission. Also what I did not put in the affidavit is, at the time it didn't seem related, but what had happened is someone accosted my daughter and I at our gate. And we had lived there for almost 20 years, and this had happened for the first time 4 days before. And I think the only reason it alarmed me was when the person walked up to the gate, he spoke to me immediately in Zulu. I mean, I'm not sure on the basis of what, except for you would have had to know who I am. And the words that followed sort of just gave it away. And when I got this message later in the week, it did make sense. Because when the person approached the gate, I asked my daughter to stand back. And from where I was, I said in English, "Can I help?" And the person replied in Zulu, "Ngidinga umeli, ukona umeli kule strat." And I replied in English, "I'm so sorry, I don't know what you are saying." And then he said in English, "I want a lawyer." And it's a fully residential area, but the way he was dressed, he walked off, And he went down the road, stood on the corner of the road, and then you could see him making a call. And so we decided to just wait to be safe till he left. So, and then this came after. But that was the sequence of those events, yes. 6.3, allegations concerning my role in interference in criminal investigations and prosecutions. 6.4, the effect of such conduct on the functioning, integrity, and independence of the criminal justice system. 6.5, allegations concerning the existence of a Khan-IDAC cabal in SAPS and your role pursuant thereto as made by Mr. Thulani Shongwe during his evidence at the Commission on the 30th of June 2026. 6.6, my relationship with Major General Khan and allegations that you disclosed to General Khan a SAPS docket relating to an ongoing criminal investigation against him. And 6.7, any matter falling within the terms of reference of the Commission. Yes.
Just help me, how does that tally with what you state at your paragraph 24, your first statement? At your first statement, you say, following upon receipts of the dockets, the information contained therein was analyzed. Thereafter, an investigation was undertaken. The investigation unearthed sufficient evidence to conclude, 1, that there was reasonable and probable cause for the prosecution, and 2, formulation of the charges against Lieutenant Kumalo and his co-accused. Then you say the charges were contained. So that's you speaking. You seem to be satisfied insofar as the evidence is concerned and the following investigations. And that would seem to be inconsistent with what you're now suggesting at the end of your paragraph 11.4, that you have had no insight into the dockets or the evidence contained in them. Read that again with paragraph 30 of your statement, first statement, which reads, I quote, once the investigation was concluded, I was briefed by the team that had conducted the investigation on behalf of IDAC. IDAC then applied for warrants of arrest against all the accused. I then prepared a prosecution memorandum and you submitted it. Now, in light of your 24 and 30, I don't know if your statement at paragraph 11.4 is entirely correct, that you cannot speak to any evidence or issues in that docket, and unless I misunderstood either the two paragraphs or this one, and I'm happy to take a correction. Thank you.
The paragraph 24, the following upon receipt of the dockets, the information contained therein was analyzed. That is all the activities by the investigators and prosecutors. It's not me who does following upon receipt of the dockets and the information contained therein. Thereafter, an investigation was undertaken. It is me giving you the feedback of what happened in that process.
Yes. And then you continue to say the investigation unearthed sufficient evidence to establish the two factors. So my reading of your affidavit then is, by the time you get to paragraph 30, and then you prepare a prosecution memorandum and a draft charge sheet and a request for the enrollment of the matter, there is you are at a level where you are satisfied that the investigations have unearthed sufficient evidence to sustain that charge sheet.
Correct.
I expect to find that in your prosecution memorandum. Otherwise, it suggests that you wrote this prosecution memorandum completely oblivious to the investigations and the evidence unearthed by the investigations, and that must be a very informed memorandum.
Yes, and it is informed through the team to myself here in 24 that there is sufficient information, sufficient evidence. Then there's, it's an engagement, and then that takes me into the compilation of the prosecution memorandum.
Which then would give you some level of insight into the level of insight,
evidence.
Yes. Okay.
Yes.
So it's not so rigid.
No, I'm not saying I'm oblivious.
Yes.
But there may be details I miss, but a lot of it is, it's in dockets, it's in documents, I get briefings, we have an engagement, and from there I'm able to take it forward.
What's the best thing to do in the circumstances? Is it to delete the last sentence altogether? Because with the...
I just need to understand what your power is relative to that decision taken by investigators. Do you have any powers at all?
We haven't exercised powers to overturn. We've made suggestions, and almost invariably many of those suggestions have been taken on board. So, as an example, Advocate Selo, the team might feel strongly about an arrest. And in that engagement, the ID says, the reasons you provide just don't make sense for why a warrant of arrest, a subpoena, should be issued. They then take that on board, and I found that they do exercise it. So they do listen when it makes sense that the proposed way they wanted was not going to work.
You talk about you haven't exercised the power. I am still trying to locate the power. Do you have that power as a matter of fact in law, or you don't?
No, I don't.
Whether you have exercised it or not is neither here nor there for the moment. Do you understand yourself to have such a power?
No.
No.
It is a power of engagement. What I'm saying is I engage them and I make suggestions. I cannot take the decision for them. I can make a suggestion, not a warrant, a subpoena.
No, I get confused now just when I thought I got it. You don't take a decision for them. They have taken a decision. My question is, do you have the power to override that decision? It's either you have it, you don't, and I'll move on.
I haven't exercised such a power to override. I'd have to check. I have to check if I have such a power to override.
Advocate Johnson, I'm hungry too, it's lunch. You can only exercise it if you have it.
Yes.
But you are not answering the first question. Do you understand yourself to have it or not to have it at all, that power?
I don't have a power to override them.
Okay.
From what I understand.
All right. Okay. That then...
At paragraph 2.5, I have no knowledge of the existence of a Khan-IDAC cabal in SEPS. I also have no knowledge of a Khan-IDAC cabal within the IDAC. It follows that if such a cabal exists, I am not party to it. I have not authorized, encouraged, or facilitated its existence, nor have I benefited from any unlawful association involving General Khan, IDAC, SAPS officials, or any other person. To the extent that Mr. Tolani Shongwe's evidence suggests otherwise, I deny that suggestion. At paragraph 2.6, I know Major General Khan, as a general based at Crime Intelligence Head Office. Before I became the investigating director in March 2022, I engaged with him in meetings with other stakeholders, attended net joints or other SAPS meetings at which he was present and to which I had been invited by relevant component heads, deputy national commissioners or divisional commissioners. In late 2024, media reports emerged concerning General Khan's alleged involvement with persons allegedly linked to the Marli murders. Those reports concerned me because I had previously met with one of the Marli sons who wanted to know whether IDAC could assist with the investigation. I informed him that IDAC could not assist, but explained how he could escalate his concerns about the investigation to SAPS management. At that stage, the concerns of the Marli son referred to above related to how SAPS organized crime Gauteng was dealing with the matter. 18. I later encountered General Khan at a Public Service Commission or Department of Public Service and Administration workshop. I asked to speak to him and told him that the media reports about his alleged involvement with persons linked to the Marli murders were concerning. I further stated that if evidence of criminality by him were brought to IDAC, it would be dealt with in accordance with the law. 19. After the engagement referred to above, I had very limited contact with General Khan, and I've had no contact with him for approximately the past year and a half. The allegation referred to above is also vague and unsupported by particulars, No particulars have been provided as to who made the allegations, which docket is implicated, when or where the alleged disclosure occurred, how the docket was allegedly disclosed, or what information was allegedly conveyed. This is a serious allegation to make against a person holding as high a position of responsibility as I do, so that I, Chair, would justifiably have expected particularity to accompany the allegations for any meaningful engagement with them. Should I be required to answer questions arising from this affidavit or any other matters in respect of which it is determined that I may assist the Commission, I am willing to make myself available, subject to reasonable notice, access to sufficient evidential material to which I am required to respond, and my rights to legal representation. That ends the affidavit. So we would chat on WhatsApp, or we would talk to one another if we saw one another, but we didn't socialize, in the word socialize, so we didn't go to lunch, visit one another, etc.
But you had non-work related interactions.
Non-work related
Thank
interactions.
you.
Yes.
I might be mistaken, but I think at some point we had evidence that you attended his 50th or 55th birthday party.
That is
Was
correct.
it after this date?
No, sir.
When was that?
Oh, I speak under correction. I don't know when he turned 50. It might have been in 2020 or 2019. But it was, he invited my husband who worked at Crime Intelligence, and when we got there, most people who had been invited with their partners or spouses. And we attended the birthday, attended the dinner. We probably were the most ungracious guests because it was very busy. And as soon as we had had dinner, I said to my husband, can we leave? And we didn't even greet the host. We had left, but we did attend it, my husband having been invited, and I attended.
And I take it you were invited to that birthday party because you already had a personal relationship with him?
Yes, he knew both my husband and I, yes. He knew me as well.
To deal with paragraph 20, you recall that paragraph 2.6 of the subpoena required you to speak to your relationship with Major General Khan generally, and specifically address the allegations that you disclosed to him an SAPS docket relating to an ongoing criminal investigation against him. Now, it says an ongoing criminal investigation. I read one investigation. Your response is at paragraph 20, the allegation referred to above is also vague and unsupported by particulars. No particulars have been provided as to who made the allegation, which docket is implicated, when or where the alleged disclosures took place, how the docket was allegedly disclosed, and so on. Say this is a serious allegation against you. Now, as at the date of this statement, you could not respond particularly to the allegation that you had disclosed the docket to him. The subpoena speaks of a docket. Your answer seems to suggest that you are not able to respond to paragraph 2.6 because you haven't been given the details of the docket, which would suggest that you are not in a position to do so because there may very well be more than one docket. Is that where we land?
No.
Okay.
For me, your relationship and allegations that you disclosed to General Khan, a SAPS docket relating to an ongoing criminal investigation, I was seeking the details of this docket and who made the allegation, because on the 10th, I didn't have that.
My apologies. Sorry. Against General Khan himself.
Yes.
That is the important rider. So the allegation is about you disclosing a docket to General Khan regarding an investigation into General Khan's conduct. That's how precise it is. So your answer, when you say no particulars have been provided, I'm not clear what particulars, you say which docket is implicated, then it leaves with me the impression that there may be more than one docket implicated. You just want clarity as to which docket is implicated, where you disclosed to General Khan a docket relating to ongoing investigations against him. I'm struggling with your response at 20, and I would like you to clarify, perhaps. Because the subpoena seems to suggest one docket.
Yes.
Your answer seems to suggest I can't pinpoint the docket because you don't give me the details of which docket is implicated, implying there may potentially be more than one.
On a point of correction,
Yes.
there isn't more than one.
Okay.
And it became, and at the time, I didn't recall disclosing a docket.
Yes.
When the evidence is then presented and witnesses testify, I'm replying to this affidavit on the 10th. And then people are testifying on the 10th. And it is only then I realize what is being referred to. And hence the third affidavit that was then made. Because I now have more details about the docket that is being alleged to have been disclosed.
So the effect, some effect of that is, had the witness not testified, you would still have not responded to.
Okay. All right, please go ahead, Advocate Johnson.
It's just to indicate, Commissioners, powers and functions of the investigators. 29A, subsection 1, an investigator may, subject to the control and direction of a head of an investigating directorate, exercise such powers and must perform such duties as are conferred or imposed upon him or her by or under this Act and any other law, and must obey all lawful directions which he or she may receive from a person having the authority to give such directions. And then it goes into the powers that the investigators may have, which is search, seizure, arrest, execution of warrants, securing the attendance of persons in court, the service or execution of subpoenas, and the investigation of offenses. It is in the briefings that we receive that it is usually these operational matters that are discussed. And so investigators may be subject to the control and direction of the head of the investigating directorate. But when we read back with section 20, these matters are still incidental to prosecutions. And so if the investigating director disagrees with anything, I have the authority to then say, this cannot proceed, this must not happen, and or as I indicated earlier, you have to correct this. If we do not have it corrected, there's insufficiency of evidence, it cannot proceed.
Okay, so you add this in response to a question as to what the function or oversight functions entail and the powers you have over decision made by investigators. So, and if I understand you correctly, where we land is that, do we land at a place where now we understand each other that you have the power to override their decisions?
That is correct.
Okay, thank you.
6, the allegations are contained in a docket, which is now with the NPA for a decision on whether I should or not be prosecuted and further handling. That this is so was confirmed by the NPA on 10 July 2026, as well as by the witness McLean when he testified. Now that the matter is before the NPA on the basis set out above for a decision on whether I should or not be prosecuted, various consequences emerge. One of those consequences of the need for me to have my rights protected. Paragraph 8. Thus, when I testify on those matters, should I be called upon to, I will exercise my right not to incriminate myself under Section 35(3)(j) of the Constitution of the Republic of South Africa, read with Section 3(4) of the Commissions Act of 1947. These instruments guarantee my right against self-incrimination. 9, I hold the view that the Commission's fact-finding mandate does not override my constitutional protection against self-incrimination under any circumstances. For these reasons, this affidavit is submitted to place my position in regard to the testimony of the witnesses identified above formally before the Commission. Also, I take this opportunity to correct certain assertions, and those were then dealt with already, Advocate Selo, that is 10.1, 10.2, as well as paragraph 11.
I confirm, thank you.
In summary, apart from correcting the errors identified above, this affidavit records my response to the Commission's latest notice, confirms that the allegations against me are already before the NPA for a prosecutorial decision, asserts my constitutional and statutory right against self-incrimination. Accordingly, I place this affidavit before the Commission to preserve my constitutional rights, to avoid any unfair prejudice arising from parallel prosecutorial processes. Conclusion. Lastly, I see the need to state, paragraph 14, that prior to my then scheduled appearance on 13 July 2026, I took ill and did not appear before the Commission. I placed before the Commission a medical certificate on which a dim view was taken. I have since approached my doctor for the preparation of what I believe is a medical certificate that would be acceptable to the Commission for its details of what led to me being indisposed. It will, together with this affidavit, be delivered to the lawyers of the Commission. I request that the medical condition I suffered from not be made public. Should I be required to answer questions flowing from this affidavit and other matters in respect of which it has been determined that I would be of assistance to the Commission, the same of subject to timeous notice and the right to legal representation, I would be willing to make myself available for such.
If she can't give a response now, I'm happy to leave it there, Chair.
Please restate your question, perhaps, for the benefit of Advocate Johnson.
Advocate Johnson raises in the third statement the right not to self-incriminate. And we have, I think, gotten to a point where at least she and I agree that she can invoke that right in response to specific questions as we go along. Now, I consider section 28, sub 8A and B read with sub 10, that the right she seeks to assert is not the right afforded any person interrogated by the investigating director or the directorate. And I wanted to understand if my understanding is correct or whether there is the same right. My reading of section 28 sub 8 read with sub 5 would seem to suggest that it's not. Which would mean the witnesses that they, no, not witnesses, the persons that they question cannot refuse to answer on the grounds that they would expose themselves to criminal charge. And it is precisely that ground she seeks to invoke going forward in refusing to respond to questions. It need not detain us. It might be a matter that Advocate Johnson may consider overnight. I just want to know where we land on this right against self-incrimination.
Mr. Law, what I want, yes. May I suggest that if we leave it at Advocate Johnson to consider this overnight, you may also want to have regard to Regulation 8.2, which speaks to the treatment of self-incriminating answers before the Commission. This is the regulations of the Commission, so consider that as well.
Of this Commission?
Yes.
Thank you, Commissioner Baloy.
Oh, sorry, it now works.
Yes.
I was thinking that maybe it's not working because We are now where we are. No, that's fine. I think the issue I wanted to raise has since been taken care of. Now this matter, it being one that is going to be considered by Ms. Johnson overnight. Our concern was of what consequence really is it. Ms. Johnson is before the commission, the rules of the commission apply. She's not before IDAC, she's not before the ID. It may very well be that the Act accords her more rights than she otherwise would have, or vice versa. But the rules of the commissions are the rules of the commission are the rules of the commission, and that's what applies. To the extent that the ID is before you today, what operates here and what regulates the commission trumps over whatever else she might be entitled to elsewhere. She is not elsewhere now, she is before you.
Advocate Johnson, Colonel Padiachi said that he has never been furnished with copies of affidavits that support Section 27 referrals. He testified that all that he has ever been given, as I understood it, throughout his stay at IDAC, are oral briefings given to him by senior investigators or prosecutors. I'm not sure which one it is now. Let me outright say that that doesn't make sense at all to me. I say so because what needs to be investigated would be contained in the Section 27 referral affidavit. Why a senior prosecutor or investigator would hold back that referral affidavit simply escapes me. Did he tell us the truth with regard to this or not? Is that the practice followed at IDAC? If it is, which I would find very strange, why would there be such a practice?
As I indicated, Chair, once I have a Section 27, or it's come from Mr. Sissoko, the necessary deliberations have been made, they go to a team. So the team would have access to the Section 27 because the prosecutors...
Would investigators at the level of Colonel Padiachi be part of that team or not?
The team has different levels of investigators and prosecutors. They have to sit and deliberate on this document and to work out what investigation would have to be instituted, what the allegations would be.
I want to understand, when you are talking about a team, who are you talking about? Would this, for example, include Colonel Padiachi?
That is correct. The team will have investigators. So if I take this team, it is investigators and prosecutors, both criminal and financial investigators, and he is one of the criminal investigators in that team.
And obviously, it makes practical sense as they debate issues around what needs to be investigated. It makes practical sense that the source document, which is the Section 27 referral affidavit, should be there in front of them.
In order for them to deliberate,
yes.
What are the allegations?
Yes.
Can we make out offenses?
Yes.
Is there sufficient to bring an application to the investigating director for the institution of an investigation? So I don't know why he would not have seen this one. I also heard when he testified that he said he had not had access to it. It is something I can find out, but it is not ordinary practice that no one has sight of every document. Of course, it depends on how they are working. Someone might see something, someone not, but I do not believe that there is a deliberate withholding of the documents within a team, from a team.
Would there be any reason? Colonel Padiachi mentioned the name several times of this person above him, this senior.
Chief Perumal?
I think, yes. He mentioned that name a good few times. Would there be a reason why Mr. Perumal would hold back that document?
Not at all. And from what I do recall, when the document was handed, it was handed over to one of the prosecutors so that they can go to the team. The prosecutors are the ones who usually will do the legal drafting, but that document does get shared. I did ask Chief Perumal after this testimony,
Yes.
and
hearsay evidence is admissible here. What did he say?
he did say that he did not withhold